This is Duke University.
Siegel, and on behalf of the program in public law here at Duke Law School, Dean David Levy and I would like to welcome you to today's event entitled Covering the Court, a conversation with Adam Liptak and Neil Lewis. Adam Liptak covers the U.S. Supreme Court for the New York Times. Mr. Liptak's column on legal affairs, entitled Sidebar, appears every other Tuesday. He also has written for various publications in The New Yorker, Vanity Fair, Rolling Stone, and several law reviews. Mr. Liptak was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009 for a series of articles examining ways in which the American legal system differs from those of other developed nations. A graduate of Yale College and the Yale Law School, Mr. Liptak practiced law at a large New York City law firm and in the legal department of the New York Times Company before joining the paper's news staff in 2002. He has taught media law at Columbia University School of Journalism, UCLA Law School, and Yale Law School. We are very pleased to have him with us today. Neil Lewis was a correspondent with the New York Times from 1985 until his retirement at the end of 2009. He remains a contract writer with the paper. His work has appeared in several magazines, including The New Republic, The Washington Monthly, Rolling Stone, and the New York Times Book Review. Mr. Lewis was born and educated in New York City, and he holds degrees from Union College and the Yale Law School, where he was a Ford Foundation Fellow. He's a co-author of a book published by Random House about Aldrich Ames, the CIA officer who spied for the Soviet Union. Mr. Lewis was most recently a general assignment and investigative correspondent in the Washington Bureau of the Times. He has covered presidential campaigns, Whitewater, the business of lobbying, Supreme Court confirmation proceedings, and the detention center at Guantanamo, among other assignments. He's also presently teaching here at Duke Law School, and we are very fortunate to have him as a senior lecturing fellow. So welcome both.
Thank you.
Welcome to Duke. Thank you for being here today. So, Adam, you occupy a position that for court watchers, for members of the bar, and the judiciary generally, it's a very significant position. And I think we'd all be interested in hearing how you see your role and perhaps how you think it might become distinctive for you as you move through your career.
It's a very challenging beat. You don't get to use the ordinary tools of reporting. It's such a treat for me to be here with Neil, known to his friends as Nick, who is an exemplar of what reporters really do, which is to say what Supreme Court reporters do not do, which is to try to find stuff out that other people don't know, to call people up, to buttonhole them, to figure out what's really going on. Whereas the job of the Supreme Court reporter is really a translation and analysis effort. You're looking at the public acts of the court. The public acts are very rich. The cert grants, the arguments, and the decisions, and you're trying to, on a punishing deadline, make them clear for educated readers. And you're talking to two audiences at once. On the one hand, you have Supreme Court specialists whose approval one seeks and who you want them to think you're a smart guy, and you want to give them value added in addition to, and this is a recent phenomenon, many of them will have seen the opinion. It wasn't so long ago. Linda Greenhouse preceded me, as you all know, did the job for 30 years. I'd say for 20 of those years, we would routinely run long excerpts from opinions in the next day's New York Times. Why? Because that's the first time anyone saw the opinion. So you'd be reading the analysis alongside of excerpts of the opinion, and if you practiced at a law firm as I did years ago, a week or two later, you get the slip opinion. It would be passed from hand to hand. Now it's up on the web at 10:15, and even if I'm writing fast, and even if I'm filing for the web during the day, it'll be hours before I've said anything, and yet you're trying to feed that audience. At the same time, you have the larger audience of people who are not obsessed with the court, as a surprising number of people are, and you're trying to give those people insights into not only what's on the face of the opinion or whatever the public act you're writing about, but some sense of context, some sense of places in which perhaps the majority opinion is being not fully honest, the likely consequences of decisions, what it might say more generally about trends on the court or about alliances or not on the court. And yet, you're doing this in a kind of commodity fashion. You're doing it day after day, side by side with what is still a quite robust Supreme Court press corps, even as court coverage in the U.S. Among most papers is shrinking dramatically. The press corps at the court is very strong, full of veterans who've been there for a long, long time. And if you put our stories side by side, these kinds of bread and butter commodity daily stories, they look very similar. And that makes you wonder what, as the question suggested, whether you're doing anything distinctive. So I have been trying through the column and through writing about different subcultures at the court, the SG's office, the clerks, the people who stand online all night long, the various other obsessives, and trying to find intellectual themes that run through some of the cases, trying to find different ways to talk about the court, because I think the American people are deeply invested and curious about the court, but find the day-to-day decisions, and who can blame them, often very technical and very dull.
So I'm wondering who you regard as your client or your set of clients, right? And specifically, is the court part of who you regard as your client? Do you regard it as your responsibility to translate what the court is trying to say for the public? Because law professors often hear that they spend too much time worrying about how the court speaks to the public because the public doesn't read opinions, right? But they do read the New York Times, they do read the Wall Street Journal, right? So do you see it...
Or at least the Times.
Do you see as part of your responsibility you're working for the public, right, or you're also working for the court to try and get the court's message to the public?
I owe no allegiance to the court. The court is my subject. I write about the court. Whatever wishes the court has, and the court likes to be treated because, for obvious reasons, all of its power flows from its kind of mysterious authority. I don't need to tell you, they don't have armies, they don't have money. People, they like to be taken very, very seriously. I don't view that as my problem. I like to bring a little mischief to the task, and if it displeases them, if it doesn't convey what they want to convey, not my problem. That's not to say I shouldn't be straight and honest, but it does not occur to me that I should in some way spread the values of the dignity and majesty of the court. Not my problem.
You mentioned, you compared your job to what Nick does. Do you find from time to time that the justices will talk to you? I'm not asking about any particular justice, although there are only 9 of them. But will they explain something that has to do with an opinion?
It's not hard to get social time with almost all of the justices. They properly don't talk about pending cases. They're also themselves generalists, so I'm not sure they're the first person to turn to if you want to really understand some nuance of bankruptcy law or whatever it is. But I guess the short answer is that journalistically valuable interactions with justices are rare.
And what about clerks or former clerks?
I don't try to talk to current clerks because it really scares them too much. And former clerks are not hard to talk to, and it's hard to imagine that situation in which what I would want from the former clerk is some really super secret stuff about who switched votes in some case. But former clerks can be very valuable about the culture of the court or about intellectual trends and other things.
We sit here with 2 former Supreme Court clerks. So.
Well, Neil and I, a couple of years ago, we interviewed Jeff Toobin, and he's written this book about the 9, and after the colon, I think it says something, the secret world of the Supreme Court. But you made the point, which I agree with, which is that the court is, if you think about government agencies in general, incredibly transparent.
I got this very frustrating request from my editors not long after the Citizens United campaign finance case came down. He said, "Can you find out what was really going on?" I said, "Well, we have 180 pages of them explaining what's really going on." "No, but there must be some," and it's not clear what that question wants, except that they think that the court, like the White House, there must be some kind of, there's this journalistic piece of jargon, a tick-tock, a reconstruct. There must be somehow we can put in that particular decision particularly, but others as well. What's really going on is on the face of the decision, as you suggest. They are the branch of the government which explains its actions to a fare thee well.
But I was going to say, however, I do have I thoroughly agree and don't dispute that in any way. But I wanted to note an example where it was the other way, and I think the statute of limitations has passed on our secrets, how we go about things. After Bush v. Gore, a monumental case and a case that any observer could presume had lots of interesting behind-the-scenes interactions and relations. We did, and this goes to the Dean's question about whether the justices talked. The Times did run a story based on investigations, and I think I'm not revealing too much to say that the reporter did speak to some of the justices. I think that was apparent. And it was an extraordinary grant from most of the justices who spoke to the reporter. But the ground rules they insisted on were so extraterrestrial and strange, and that the story was so oblique that it had no what we call bounce. No one picked it up and said, ha, this is what really happened. But it was this effort the reporter got, and it was Adam's predecessor, Linda Greenhouse, spoke to the justices on some special codified deep background and produced a story, but it actually didn't have much oomph in it. Do you remember this?
Yeah.
And but it was rare that these justices were willing, because of the extraordinary occasion of Bush v. Gore, they did want to get out some things. And they sort of got out, but it was very subtle.
Yeah, I had a couple. Jeff Toobin and Jan Greenberg and others, if you can write in this kind of omniscient way, which is not, the Times, it's very hard to get away without some level
Though
of...
we are omniscient. We don't write that way.
The editors
Because you're final.
and readers expect some attribution, so it's hard just to say that something is so, and trust me. But if you can write like that, and if some time has passed, and if the particular justice in question is not cited by name, getting that kind of information is not that hard. And then the other phenomenon we've seen lately especially, but growing, and much more accessible with the advent of webcasts and so on, is that the justices are out there talking all the time. If you wanted to keep up with Justice Breyer, that could be a full-time beat. He gives speeches every other day.
So have media and technology changed both of your jobs from what it used to be?
Oh, enormously. But boy, yes, 'cause things are out there fast. People are talking everything. Well, for one thing, and Adam had alluded to the opinions being out. Everything we write, everyone has access to. We're no longer sort of exclusive custodians of anything. And I might also say we're ripe targets for criticism and very occasionally praise, but mostly criticism.
But I think that's to the good. It used to be that we'd write something in the paper, and if you were unhappy about it, you could write a letter to the editor, which we might or might not publish, or you could write to the Columbia Journalism Review, which 3 months later might or might not say something about your complaint. Now, I think this is to the good. There's a lot of critique and criticism of everything we do. There are a lot of very good blogs, some specialized on the court, some specialized on particular areas of the law. And I do find that that's very helpful, so that if I need to reach out to an expert in election law, I'm not going to do what a reporter a generation ago did, which is no matter what the subject, call Larry Tribe. Now you're going to call that person who has demonstrated his or her expertise because they blog every day about sentencing law or election law or patent law or whatever it is. So that aspect of academic life has nicely merged in a way and allowed us to be part of the conversation and bring people into the conversation who are specialized into relatively narrow areas of the law instead of just going to the big-name public intellectual prepared to opine on anything.
But is the court behind the technology and relatedly the accessibility curve? Because you both seem to suggest that the court is very transparent and accessible, but one way it could be a whole lot more accessible immediately in the way what you folks do is by having cameras in the courtroom, right?
Yeah, I see no argument, no plausible, rational argument why there should be no cameras in the courtroom when we're talking about any kind of appellate court. Mm-hmm. There's just, and I've heard all the arguments. They range from the narrow self-interested of David Souter. He didn't want to be recognized. He valued his privacy, to the idea of which you can say about a trial court too, well, it will be truncated, it will be chopped up, sliced, spliced, diced. Well, we live in a world where information is overwhelming. It has to be shortened. And I think it's only a matter of time. Trial courts, the arguments are a little more cogent, but I also believe that's due any time now.
I agree completely. There's no principled reason not to let people see their government in action. When I went and did a story about the people waiting online all night to see the argument in McDonald, the follow-on to the Heller Second Amendment case, we make people wait all night in the cold to see their government at work. It's insane. It's offensive. And I'm not as optimistic as Nick that it will happen anytime soon. When I talk to the justices now, they're more concerned than ever with the rise of YouTube and Jon Stewart, that some of the goofy things they say, and they do, will be, mocked. The argument that sound bites are illegitimate would suggest that the print equivalent of a sound bite, known as a quotation, is also illegitimate. I don't see that at all. The court is, they've recently upgraded their website to, about 1990 status from what one commentator called medieval status. You still don't get direct access to merits filings. They send you to the ABA's site. You don't have any electronic access to cert filings. They do post the transcripts quite quickly, which is very helpful.
And the audio files are how?
The audio, they very rarely, this term, if it counts for this term, the only audio they've released was Citizens United. They turned down the McDonald case. They make judgments about what's newsworthy, the Chief Justice does, itself a very problematic First Amendment proposition. And they release audio at the end of the term, and it goes up on this site, which if you haven't poked around in is fantastic, called Oyez, where you can, Neil Katyal in the Solicitor General's office told me that he listens to arguments as he jogs. That may be going overboard. But they're really cool. And also the announcements of decisions from the bench, which don't always track very closely the actual decision, and even better, the oral dissent from the bench. Those are also, many of them, up on this Oyez site, so that's a lot of fun.
The reason not to televise, it's sort of the Heisenberg principle. It's that you'll actually affect the substance of what goes on. Now, I think a distinction should be drawn with the trial court, because you're dealing with witnesses and others whose privacy is something of an issue, and who can be, I've seen it can be quite intimidated by the media, and I think that's an issue.
But I think the Heisenberg principle is exactly right. The presence of the observer may change the quality of what's being observed, I say, to the better. I find that when I'm under scrutiny, I perform better. And to put it another way, if we're worried that the presence of observers might affect people in a bad way, maybe we should kick out the print press. Maybe we should kick out the public and just do the thing in secret.
I wouldn't make that argument, but I think there's a difference when you're thinking about vulnerable people who are frightened by the process.
The trial court question.
I think it's really quite different. The Supreme Court is also, I think, different from the appellate court, and they are huge public figures. And I don't really want to say this because they'll be upset with me, but I think there's a little bit of it's hard for them to argue that they want to maintain their privacy when you can also go on C-SPAN and see Justice Thomas's book party, and they are doing so much public speaking.
Well, of course, there's another way to maintain privacy, right? There are alternatives, right, for the present justices, right, who would be happy to serve on the court and compromise their privacy, right, so they could return to private life. But I mean, one argument you hear about oral argument is that it's supposed to serve a purpose. It's supposed to give the justices the information they most need to decide the case.
Yes, and eight justices believe that's the case.
I realize that one could contest that's what actually goes on, right? But if you think that oral argument is supposed to serve this function, then might you be concerned with people, litigants, not giving the justices the information they need, but rather making the statement, right, the political activists or people outside in politics want to hear?
But why do you think that's different when someone's writing it down versus when someone's pointing a camera at it?
I think when you think about the pervasiveness of TV as well as cameras showing up on YouTube, right, versus print, I can see a potential difference. I mean, a response I also see is well, the justices are there to police bad behavior, right? Which is you penalize litigants who don't give you the information you need. So I'm not sure that this is.
Let me suggest to you that everything you say has a bit of substance to it. Has great truth and wisdom to it.
Right, that's right.
But
Right.
the reservations you express, which are cogent and plausible,
Right.
and you as well,
Right.
I think they will all disappear. It's just out of custom, we haven't had it. They will all disappear, I
Right.
predict, shortly after a year or two after it. All of these concerns will evaporate.
And bear in mind, these are very boring arguments. And if you haven't read the briefs, you will have no idea what's going on.
That's right.
And they will have a very limited, although intense, interest among people who care about the court, among scholars and engaged citizens who should have access to the information.
I've often thought, though the voices are out now, every time I see the same World War II documentary, the Japanese people never heard Hirohito's voice until he announced the surrender. The justices are so remote, people,
Right.
that would be, I look forward to that day, remarkable when you see them say, no, wait a minute, or, well, that Scalia he's a very tough questioner. Rude, I just said.
Let's use this as a way of getting into the confirmation process,
Right.
because I think we'd all agree, or maybe we wouldn't agree, that the presence of the media has affected that process. I would say distorted. You might not say that, but I would say changed it.
The confirmation process.
The confirmation process dramatically. And has it improved it?
No, I think it's a terrible, broken process right now. I'm not sure, and I'm not being, I'm just not sure. I agree. The media it's become a political process. The blame for it, I think, is in the partisanship, and I think it's a long arc where both sides now have grievances against the other, and no one wants to, I'm talking Republicans, Democrats, liberals, conservatives, wants to declare a unilateral ceasefire. They all bring it into grievances, and there's an arc of history about this that explains it. There's an arc of history going back to the first nominee who was rejected in 1795, but our modern troubled system goes back to the Bork nomination in '87, I think, that began it. It defined a lot of the things that made it a political process, not necessarily bad. We live with them today. The grievances from that among conservatives inform their reaction and response to this day, and the reactions to liberals. So Judge Bork was a law professor at Yale and then a federal appeals court judge in the D.C. Circuit. And when he was nominated by Reagan, it turned into a raucous national battle, though there was a great political dialogue at the same time, as well as some, crummy things. And we have that legacy today, and I don't really see a way out of it. But I don't see the media as, also the people who come before the Senate Judiciary Committee, the nominees, it's not an honest process. And they're interested in just getting past this so they can get on to the quietness and reclusiveness of and non-responsiveness of whatever court they're nominated for. So, but it's a real battle for the third branch of government. I think it was joined by, in a pitch way, by the Reagan-aughts and continues today.
But if you were just to describe it, if you just were to listen to it and take out all the political element of it, I think you'd be describing something where someone makes an argument in the guise of a question, someone else responds to a very different question, and then the person that asked the question is apparently unaware that their question was not responded to, but actually doesn't care because they've got another statement to make that is in the guise of a question. And it's not, they actually could be on different sides of the planet and it would be just as effective.
Right. So what you say is
Modern
true,
technology.
but But the media is the only good part of this process. The confirmation hearing itself, as you're both suggesting, is completely broken. It's a farce. It's intellectually dishonest. Nominees flirt with perjury. But the 6 weeks or 2 months leading up to the confirmation hearing, where there's intensive vetting of the candidates, is very valuable. And to focus too much on the confirmation hearing, I think, is a mistake. But the exercise of reading through everything this person has ever written, to talking to friends, neighbors, colleagues, associates, that will very likely bring out important information. It sure did with Clarence Thomas. Unfortunately, the lesson that everyone took away from the Bork nomination was that you can't have an authentic intellectual dialogue because it will get you in trouble. So now we've denatured and made empty the confirmation hearing itself. But the confirmation process, if viewed as a 6-week, 2-month public debate and vetting of a candidate, strikes me as valuable.
But if we just focus on the hearing, I mean, doesn't the media, and specifically TV, enable senators, right? So you're focusing, enable senators who want to make statements, right, in the guise of questions. If TV was not there, they wouldn't be doing that. There would be no one to listen.
Apparently the solution is to get rid of TV everywhere.
No, that's not.
And that would work for you.
I'm not.
I'm indifferent.
Or interlocutors.
But is the media at all implicated in what is going on? Right.
But again, I mean, the senator's going to say what the senator's going to say, whether it's a room full of people or a room full of people with pen and paper or a room full of people with pen and paper plus cameras. The notion that the camera is the thing that changes, I don't buy it.
The camera is only, in the way I think you're suggesting, is connoting that it's a very important event.
Mm-hmm. I think it's also.
But their grandstanding is second nature.
But if you add the cameras and the news, I mean, if you take the media out of it, it used to be, and you just have the meeting in closed session and coming up with a decision, right? It's not going to be nearly as political event in the sense you're using the word political.
It used to be like that. Justice William Douglas was nominated, and he waited outside, and he said, "Any questions for me in there?" And they said, "No, you're fine, you know." But now we have, I believe we do value transparency, even if we have to put up with the punishing speeches of
the notion that
senators.
more secrecy is the answer to political grandstanding by politicians.
What about the gotcha quality of it? So you say it's valuable to comb through every statement that someone has ever made and look at
Judicial writings especially.
and judicial writings, but other writings as well. I mean, Bork's controversial statements were not, I don't think, in the context of...
No, he was angling by then.
So, okay. And so you're going to produce, they'll say, well, nominees have trimmed, or perhaps we'll see a new kind of nominee, a very bland sort of person who's very careful about that they never have an opinion on anything or they never express it at any rate. So, again, I think what we're probing is this question to the extent to which the translators here are actually affecting.
I'm coming to agree with you because I can think of an example. In Sonia Sotomayor, our most recent confirmation, combing her record, a discovery, a gotcha, which turned out to be a gotcha, was a speech he had given to, I may have this wrong, to La Raza.
At Berkeley.
At Berkeley, a Hispanic student law group, where she said something of the order of, I think decisions by a wise Latina judge, did she say woman, the Latina, could be better than those rendered by a white male judge. This was, to me, a benign, innocuous, she was giving a pep talk to an interest group of Hispanic students. She did not mean to say that Hispanics are genetically superior in the law and jurisprudentially to others, but this was a distortion. And it had an effect. It had an effect because when she went before the committee, she was beaten up a little bit over this, and she had to be a supplicant and show abject remorse over this and reinterpret it. And in fact, she also did something because of her weakened position. She adopted a preposterous framework, template that was used by a lot of the Republican nominees, that judges really are just essentially sports referees. Some call them umpires, some call them, that there's no decision in here. So therefore, I couldn't have meant that because, yes, it's an automatic thing, How do people come out with different things? Well, that's a mystery. But so, and that was intellectually dishonest, I thought, and was sort of disappointing because she knows better. But what they tell nominees in various forms, they say this is a pass-fail test. You just have to get confirmed. It doesn't matter what you do. It doesn't really matter what you do. You just have to get confirmed. So if we have to concede a little bit here, the handlers in these things typically are political handlers figuring out how to get through and get enough votes. So I thought that was a great distortion and substantive and mattered. And I give that example of her. She had one other comment that was picked. I don't remember what it was, but that one was the main one, if you recall.
So what's the solution, right? What's the solution? Focusing on the confirmation hearing, right? So you have John Roberts saying, I follow the law, and that's all I follow, right? I have no agenda. Sonia Sotomayor says, I follow the law, that's all I follow, I have no agenda, right? No one remotely acknowledges they have completely different views of what the law is and all the cases that people care about most, right? Which is why the stakes are high. So what is the solution? Do we get rid of the confirmation hearing part of the process? Do we do it differently, right? To evoke substantive responses that acknowledge the reality of disagreement?
Well, you're asking what's the solution to eliminating some inevitable degree of nonsense that attends these things. And it could be many things. It could be a senator saying, come on now, that's not so, and us reporting it. The only analogy that comes to mind is switching gears and talking about the healthcare debate, where the media, and that's us, we're often straitjacketed by this traditional sense of fairness and what do both sides say. In the healthcare debate, I was quite struck that you could see the death panel argument. You saw something rather unusual. You saw the media actually say this is crap and go after it. When it gets to something more subtle like that, we're not as straightforward and direct.
I don't know what the answer is about the confirmation hearing, and I don't think it's exactly the press's job to figure that out. But I do think an example of the point I was trying to make earlier, that the vetting process that precedes it is aptly illustrated by Harriet Miers. She was not qualified to be a Supreme Court justice. As people focused on her record, that became clear. It never got to a confirmation hearing, but we got the right outcome.
I'd like to get your views on a couple of things. The media, and particularly the print media and the legal profession, because we seem to be in a period of disruption, to say the least, in media and in the legal economy. And I know both of you you're right in the heart of this. The New York Times and the great newspapers around the country are obviously under a great deal of stress. And what does this mean for the democracy?
The numbers don't look good. The trend lines don't look good. The traditional news organizations, some of them are really withering away. The Times not so much yet, but our trend lines are no different from anyone else's. In the short term, I don't see an alternative to the authoritative, comprehensive, honest broker role that we like to think we play. But in time, the new technologies will rise up, and people will demand, I hope, the kind of information they need to govern themselves. I think we'll probably get from here to there somehow. In the short term, it doesn't look good.
Nick?
I agree. I think it doesn't look good. I don't know where we'll get to. I think it's such a great mystery where we are now as to what's going to happen. The Times is struggling. I took a buyout when they reduced the staff by 8%, and these are what does it mean for the paper itself, the product? Well, it's a kind of a subtle thing. You might not notice it, even if you're a very careful reader. But the Washington Post, for example, which is far more reduced, even nominally sophisticated readers can see that it's only a portion of what it once was. It feels flimsy. There are less things covered. The Times is it's not so apparent, but we're sort of on the edge. So it's a very dismaying situation. I don't know the answer, though.
This sort of fragmentation of authoritative sources, so that I or anybody can pick who they want to hear from on various topics. And in one sense, I suppose it's incredibly rich, but in another way, it might be balkanizing.
It's hard to know. The Times holds itself out, and I believe this is true, that we're going to give you quality coverage across 200 different subject matter areas. Now, let's assume that I'm making it up, there's a site that does baseball better than anybody else. And our baseball coverage is first rate, but it's not this site that only does baseball. And you sort of then take this across a number of different subject matter areas. Maybe you're better off to be your own editor and curate your own, information experience. I don't know. It's a lot of work, and it leaves open the possibility that you're going to be attracted to people whose political views already match your own, and there'll be this kind of feedback loop, and you won't be getting a diet of fairly straight information.
As you know, or you will soon know if you don't, next year, 2011, the Times will embark on what it hopes is a solution and charge for content. Some people call it the original mistake when web aggregators like the Huffington Post and the Drudge Report, all kinds of things, started to take Times stories and put them on their website. The Times and other major papers had a threshold decision. Are we going to enforce our copyright, our property rights here, intellectual property rights here, and a combination of things. I thought it was just so difficult to get a hold of the whole world and go after everybody that, and they also comforted themselves, I believe, with the thought, well, we're getting hits because you have to, hits on our website when someone, I'm sorry, I'm not literate with a word, I can't think of it, but so that's a good thing. Well, it hasn't been a good thing, so we're going to try to charge in 2011. I think with some initial thing, you get either a small number of stories or the tops of stories, and then you have to pay, which is why at this point in the talk, if anyone wants to stay, they'll have to pay. This is the end of the free portion of my talking.
Pass the hat.
So this is a bad time to ask if you're hiring young lawyers. Huh?
How about the profession? You're both observers of the legal profession, and you've done some writing about different aspects of the judiciary and different aspects of the profession. Do you have a sense of that?
Well, I bet there are more nervous people in this room than there were 10 years ago. The big firms do seem to be going through a real disruptive moment. As a former in-house lawyer, I think that if at the end of that we do away largely or completely with hourly billing, the world will be a better place. What a perverse way to bill for work, that the most inefficient person gets to charge the most. And as a former in-house lawyer, I never liked paying for first-year associates, whatever their rate was, because I was basically paying for their training. I would much rather pay a partner's rate for the partner to write the brief him or herself. So I think it may be that at this moment of economic disruption, some of the weird ways in which law firms have come to be structured get reoriented, and that allow, therefore, people to be put to better uses. And also, it wouldn't be the worst thing if people didn't think that the big firm was the be-all and end-all, because there are many, many kinds of legal work that's more satisfying.
You think is it regrettable, inevitable, inaccurate that the New York Times is regarded as the liberal newspaper, and it's what you read if you voted for Obama, right? And if you're a conservative and you voted for McCain, well, then you read the Wall Street Journal or the Washington Times, right? Is that accurate? Is it, and if it's accurate, is it a problem? Is it something that, the Times could take steps to try and address?
It's terrible. The news pages of the Times, as opposed to its opinion pages, hold themselves out to be straight. I believe, on the whole, the Journal news coverage is quite straight, while their opinion pages are quite conservative. And I think if you were to spend some time putting Times stories next to Journal stories on news events, you're not going to see a lot of difference. I do think that the Bush administration in particular, but other Republican administrations before it, have gotten good political gain out of going after the big newspapers as unduly liberal. I wasn't happy to see the Obama administration go after Fox News on that same ground, except from the other direction, because it seemed to credit, in a way, this notion that these are the right ways to think about things. But the horse has kind of left the barn. I think most people, there's nothing I could say, and perhaps most of you, to convince you that the Times' news coverage is not fundamentally liberal, and I don't believe it to be true.
I'm not sure if I have an opinion about the Obama administration going after Fox News. I think, but let me answer your question. It's regrettable. I agree. It's regrettable. I'm not sure there's certainly no. You asked what could be done about it. I would abhor the idea of taking any steps. You know, there was suggestions in Journal Reviews a while ago. Should the Times hire more conservative people of conservative background to be reporters? That's not what we do. You know. Years ago, when I began at the Times, many years ago, the executive editor, who was a giant, Abe Rosenthal, came down to the Washington Bureau, and I just joined the paper. I think I told you the story, and took us all out to dinner at a steakhouse. And at this stage in his brilliant career, Abe was a little manic and dictatorial, and he thought his job at that time was to keep the paper straight. True, but for him that meant becoming too lefty, liberal. He had become more conservative himself. And he looked around the room, we were all eating our dinners, and I was just a kid. And he said, I'm going to prove my point here. And there were about 40 Washington Bureau Times journalists in the room. And he said, how many of you are conservatives? And 2 people raised their hands, Bob Hershey and Nathaniel Nash. And a grand fellow named John Herbers, who was a great hero at the Times. He was one of those Southerners who heroically and wonderfully covered the civil rights movement. And he was older by then. And he stood up and said, Abe, you don't have a right to ask that question. These are professional journalists. It doesn't matter whether in their personal lives they are. And everyone was stunned because Abe, you know, you thought he would take out a machete and section you right there. And he said, you know, you're right. So I don't think there's a solution. I think it's very dismaying, and I think it's very dismaying that we're put in play by some political figures.
You guys just call balls and strikes.
That's right, we're referees.
The craft,
We're the real impartial.
you know, there's an analogy to lawyering. I think probably everyone in the room would think themselves capable of making an argument that they don't happen to believe because a client will pay them to make that argument. That actually strikes me as the harder thing than the relatively straightforward journalistic craft of just trying to say what's going on and what responsible people have to say about it from any perspective.
Okay, so let's, we've got 15 minutes, and we're eager to hear from you folks if you have any questions for Nick or for Adam. Yes?
What was your opinion on the State of the Union and Samuel Alito's comment? And do you think those kind of events would influence justices in the future, like in any of their decision making?
Well, I will confess that there's not that much candy and color in the life of a Supreme Court reporter, so it was sort of fun to have some conflict. I think it will almost certainly influence some justices not to go to the State of the Union address. I think it illustrated in one of many ways how unpopular the Citizens United decision was, and that it turns out to be good politics to beat up on it. You know, and that said, I have some sympathy for Justice Alito, who both is socially awkward, but is probably more right than President Obama was in his not true critique of the quick political précis that President Obama gave of the decision.
He's a fellow instructor here, by the way.
Alito,
Yes.
Professor Justice Alito.
Grayson?
To go back to the political nature of the confirmation process, you were both saying that television cameras have not made it more so. But given that most Supreme Court rejected nominees came in the 1800s when there were no TV cameras, the process seems to have denigrated, but it seems to just be as political. How is it not somehow the TV cameras' fault that it's become sort of the mess that it is? What else is to blame?
Isn't that the fallacy of, but they didn't have automobiles back then, and there were.
It's the fault of the internet.
Haven't we evolved a system of how political it was over the time from when the Senate first rejected Rutledge, And then there were periods where sometimes more than half the nominees were rejected. And we're in a transition now to where there's an argument, does the president does he or she deserve deference to the White House choices? Or what does advise and consent mean? I think it goes to the heart of how advise and consent has evolved over the years more than anything else. But maybe
I'm sort of surprised that there shouldn't be widespread agreement that people should get to see their government at work. That strikes me as a fundamental proposition.
Since you follow for all the time, every day, what's your batting average in terms of being able to predict where each judge is going to come down? And do they say the things that you expect them to say in the opinion?
good question.
I don't keep track. I probably flatter myself in retrospect that I saw things coming.
And forget
I try not.
mistakes.
I try not to put things in the paper unless I'm really, really sure. I don't think I've embarrassed myself so far with a prediction that turned out to be flat wrong. Although there's a lot of, seem to be prepared to express deep skepticism about. I probably got pretty close to thinking they were going to strike down the Voting Rights Act, and if I did, I was wrong about that. The justices, like so many of us, are very predictable, have certain habits of mind, have certain templates that they impose on all kinds of cases across many kind of legal subject matter areas. So they play to type, which can be amusing, or when they play against type, that can be amusing too. So to see them every day is a privileged position, but also one that gives you a lot of insight into at least the intellectual aspects of their personalities.
Are you willing to offer a prediction about the vote count in McDonald?
Yeah, I think it's going to be 5-4, the same as Heller. Going in, I would have thought there may be some difference of opinion among the conservatives about how to incorporate. Maybe Thomas goes with privileges or immunities, everybody else with due process. Going in, I would have thought that it would have been a nice thing for the liberals to say, hey, we disagree with Heller, but now that the Supreme Court is precedent, it says it's a fundamental right. Obviously, we're going to incorporate it because it's precedent. That's not what I took away from the argument. Similarly, in Citizens United, there was a complaint from Stevens that there were narrower grounds on which they could have voted in favor of the Hillary the movie, Citizens United movie makers there. And it might have been nice for the liberals to say, we're not going to do this wholesale revision of campaign finance law, but a 90-minute movie is different, or video on demand is different, or this kind of advocacy corporation is different. But I don't think they wanted to have a 9-0 in the headline. So instead, you have the 4 dissenters. I think you'll get the similar 5-4 in McDonald.
Yeah.
Do you have any sense that public expectations have changed at all over the course of your careers in terms of the quality of Supreme Court coverage, as in what kind of information will be communicated to the public about the Supreme Court?
Linda Greenhouse single-handedly elevated the quality of Supreme Court coverage, and I'm rapidly cheapening that. And before Linda, Tony Lewis, who was Felix Frankfurter, called our Washington bureau chief, Scotty Reston, and said, we got to get some serious coverage in here. Anthony Lewis gets sent to Harvard for a year of law school, comes back and starts writing Supreme Court coverage of real depth and sophistication. Linda builds on that for 30 years. So the quality of coverage, largely on the backs of those two people, is just shot up.
And an admirable successor, I can say, and modest too, obviously. You asked about predictions. I mean, this whole issue of televised, it's likely we'll have this spring and summer another confirmation spectacle at the Supreme Court level. Justice Stevens said recently in a New Yorker piece that he'll decide within a month. He's only hired, I think, 1 clerk, but he said straightforwardly, and people expect.
He's very likely to go. Very likely to go.
And then we'll have some of these rituals again.
And successors most likely will be?
Sorry?
Who's most likely to be a nominee?
Stephen Colbert, I think. You don't have to be a lawyer. You really should be a lawyer. Well, the three likely front runners or conventional wisdom candidates are Elena Kagan, Solicitor General, former Dean of Harvard Law School, Diane Wood, a judge on the Seventh Circuit, who gets high marks for being a presence there on a court where lots of very heavyweight conservative jurisprudence she has to deal with, and she's certainly held her own. But she's approaching 60, and the Democrats have learned from the Republicans who really, and I don't think there's a parallelism. I don't think the Federal Society and the American Constitution, they're not parallel. They come from different perspectives, different origins. I think the idea that the Republicans had, they wanted to put young people in the courts, and I think the Democrats are getting that, to have a longer impact. So a couple of people are already out of the running, David Tatel and Diana Motz. People are just too old. You know, their time has come and gone from when there was a Democrat. And the third, Merrick Garland, a very fine judge on the DC circuit. The other is, I think Adam probably disagrees with me, that Harold Koh is still a marginal candidate. But again, into politics, it's interesting. Harold Koh, who's the dean of Yale Law School, who's now the legal advisor at the State Department. Harold Koh went from being the dean of the Yale Law School to the legal advisor at the State Department. It's not exactly a huge, great promotion, but he has great interest in that, and he's a fine fellow. He was beaten up by conservatives and Republicans over some issues, and I believe that the reason for that was not that they didn't want Harold Koh to be the legal advisor in the State Department, but they wanted to make him somewhat damaged goods for the possible Supreme Court appointment later. A lot of that kind of politics goes on, that among the bitter memories of Republicans are that President Bush, recent President Bush, had tried to nominate Miguel Estrada, a Hispanic conservative lawyer, private practice in Washington, to the DC circuit. And it's clear that this was a on-deck position for a possible later Supreme Court nomination, and the Democrats opposed him. There have been things on the other side. Justice Sonia Sotomayor, when she was first nominated to the Second Circuit, she had her confirmation held up for that exact same reason. So this kind of strange macro politics of who can get, because there was this great pressure, political pressure, with a dividend to put a Hispanic lawyer on the court who would get theirs in the on-deck position first. Sir.
Do you think there's any impetus for revisiting the idea of term limits on Supreme Court justices?
In scholarly papers, maybe, but not in real life. No, I don't think so. I mean, I think that's, yeah.
I'd like to ask Adam. All the justices were appellate judges.
Yes.
And I think only Stevens practiced, and he practiced before the era of the class action and that sort of thing.
Justice Ginsburg will correct one if one writes that.
Yes, of course. But I should have said litigated, perhaps, in the trenches, as opposed to being an appellate attorney. And of course, the Chief Justice was a Supreme Court practitioner. And all of them have had some experience in practice, but many years ago. What do you, if you were advising the president, would you advise selecting somebody from one of the appellate courts, or would you advise going out and picking somebody with a different kind of more recent experience?
If you look at the court that decided cases like Brown against Board of Education, you saw people on those courts, senators, former attorney generals, former governors, who brought a wealth of experience about the way the government works and how the Constitution might actually play itself out through real-life experiences. Even Justice O'Connor's brief legislative experience, even Justice Souter's trial court experience, and now Justice Sotomayor brings that to the court as well, really helps inform the thinking. Justice Breyer's service on the Judiciary Committee, he really understands how legislation works. So this notion that we should have a European-style bureaucratized career judiciary, and those are the people we want to pick from to put on the Supreme Court, strikes me as problematic.
Anyone?
We've answered all the questions? Or at
In the
least-
universe.
Yeah, we made statements disguised as questions, and,
Right.
and you answered however you saw fit. So thank you for being here today.
Great
Thank you very
pleasure.
much.
Produced by Duke University. Online at duke.edu.